Good morning, Ms. Sibison.
Good morning, Your Honor. May it please the Court, I'm Wendy Sibison. I represent Frank DiBenedetto in this appeal from the denial of his motion for a new trial in a first-degree murder case, and with me is my co-counsel, Dennis Shedd. This is a case where a pair of sneakers, the sole physical evidence used against Frank DiBenedetto at his 1994 trial, turned out to be exculpatory.
The soul of the soul.
The soul of the soul, Your Honor. The question is whether new evidence that the lack of either victim's DNA on these sneakers would probably have been a real factor in the jury's deliberations. In other words, would the jury have given some attention to this evidence? And when we talk about exculpatory evidence, I think it's best to look to Justice Benjamin Kaplan, the late Justice Kaplan's definition in the Ellison case, exculpatory evidence. It's evidence that calls into question a material, although not indispensable, element of the prosecution's version of the events, or challenges the credibility of a key prosecution witness. And I would submit that the DNA evidence in this case does both. My argument is pretty plain and pretty simple. There are just a few key facts. Both victims were shot many times at close range, generating a large amount of blood at the scene. Blood spatters. Joseph Schindler testified that the person he identified as Frank DiBenedetto bent over Ciucciolo's prone body and fired 4 to 6 shots.
He didn't say anything about standing in a pool of blood, though.
No, the pool of blood was right next to the body, and there was evidence that there was a lot of fired 4 to 5 times into that body, and that blood spatters. Common sense, just simple common sense. If I'm firing over a person and there's blood is spattering, I'm going to get blood on my shoes. And that is exactly what the Commonwealth argued in this case.
Doesn't that cut both ways in that even at trial, the amount of blood was extraordinarily small, or the amount of so small that it would not really suggest that he was near?
But, Your Honor, there was evidence at trial about washing, and the Commonwealth made that point.
Washing of the shoes?
Yes, that if someone got a lot of blood on their shoes and washed it off, the test was sensitive enough to find some traces.
Now, I've not seen the sneakers, but they were referred to as soiled.
They were referred to as older sneakers, that they had turned gray rather than white, they'd originally been. But one of the points the Commonwealth made at the trial was that, yes, this is just a small amount, but and she includes in her argument that water dilutes blood but doesn't make it disappear. So that was, of course, that was an issue.
Let me put it different. It's here.
I mean, someone who gets a lot of blood on their shoes is hardly going to walk around with it like that. This was 3 days later, by the way.
I take it your point is that, unlike in some cases, the presence of blood on these sneakers was an issue in the trial.
Absolutely.
And it was one that tied this defendant to being there and to...
The only one.
No, I understand. So it's not as if, for example, years later, on some physical piece of clothing, DNA is tested for the first time, and it was never mentioned or dealt with. I mean, this was dealt with at the trial.
Well, it was dealt with, but I would submit, Your Honor, that even if there was no evidence about this at trial, I don't need to say this, but honestly, if it was just the testimony of these two witnesses, and later, and this testimony was as I just said it, where common sense would show that you'd get some blood on your sneakers, and Schindler did identify, he said, those are the sneakers that man was wearing. He was real clear about it. And we showed, guess what? There's DNA on these sneakers, but none of the victim's DNA. I still think that is exculpatory. We're not just saying
the issue is not whether it's
Yes, Your
exculpatory.
Honor.
Let me just ask you about that. If I understand it, the test that was done in 2004
Yes.
Excludes the two victims.
Yes.
But it's not, doesn't indicate that it's necessarily DNA from blood, correct?
That's true.
So how exculpatory,
Well,
if it isn't blood, of course it's not going to be there.
None of the victim's DNA is on these sneakers under circumstances under which a reasonable person would think it would be there.
but I think that blood would be there too.
I understand what you're saying. The tests for blood. Oh, okay. The test, what the Mr. Abbott did was he took a sample from 8 sites and he split those samples. And half of the sample he used a test similar to the phenolphthalein test. But there was testimony that test is not as sensitive as the DNA test. And so it didn't rule out the possibility that it was blood. It just couldn't prove that the DNA was blood. It's much less sensitive a test, and that evidence was in there. So I think that's the answer to Your Honor's question.
Now, you've been focusing on this being exculpatory. That's not really the issue. No one questions that if this information were available to the prosecution, it would be disclosable to the defense. The question is whether it, quote, casts real doubt on the justice of the conviction, which goes to the weight of this exculpatory evidence.
Fine. So that's getting back to my definition, and that's what I wanted to talk about, Your Honor. Thank you. It does go to the weight. So first question under exculpatory evidence is whether, I beg your pardon, the evidence called into question a material, although not indispensable, element of the prosecution's version of events. Well, the prosecution's version of events was that because Frank DiBenedetto stood over this man and shot into his body at close range, he got blood on his shoes. That was her version of events. It got the victim's blood on his shoes. Our evidence shows that no trace of the victim's DNA was on these shoes.
Right, but there was evidence at trial, I gather, that all that was shown was that there was blood of unknown source. Wasn't clear whether it was human blood, animal blood.
Very true.
And that he worked at Francesca's and arguably could have been stepping in animal blood.
Absolutely, Your Honor. And we agree with Justice Wilkins when he said that this was objectively, from a lawyer's point of view, marginally instructive evidence. That was our position all along. But that's not, we knew that the prosecutor would not use it that way. And she was really good, and she used it to great effect. And she didn't just talk about this as more, she didn't say this could be a plant paradox. She said that was ruled out. She ruled out every other substance when she argued to the jury, and she said, this is blood, and this is Ciucciolo's blood. And we've proven it. And she talked about the test as an objective test for the presence of blood. So whether it was marginally instructive or not, the prosecutor used it very effectively.
Well, I guess that's sort of the key when evaluating whether this casts real doubt. Is it, do we look at it as jurists, or as we hope that jurors will look at it, in which it's marginally instructive? Or do we look at it with the view that, well, the prosecutor made a big deal of it, and therefore, even though it should be marginally instructive, because the prosecutor made a bigger deal of it than was deserved, it changes the calculus?
Well, to the extent that we're suggesting that this evidence could have canceled out the prosecutor's version, yes, of course you need to look. It's not as if Justice Wilkins were sitting on the jury, he would have thought, this is not a big deal. But he wasn't. It was ordinary jurors.
But Judge Mulligan was there,
yes.
And he says, look, the evidence, the eyewitness was overwhelming. This is nothing.
Yeah, well, this court can, yes.
Well, my point is, he's in a different position than Justice Wilkins. So,
that may be so. Nonetheless, his point of view on the exculpatory evidence was, and I want to get back to that, because it's a different position we're taking. We're not just saying it wiped out the Commonwealth's proof.
Finish over there. Yeah,
well,
that's fine.
The trial judge said it had nominal exculpatory value. But this is what I want to say. If the shootings took place the way the key witness, Schindler, said they did, then why was neither victim's DNA on the shoes he said DiBenedetto wore? I don't think any reasonable person or any reasonable juror would consider that nominally exculpatory. And we're talking about reasonable jurors.
What was the evidence as to these were close filings, correct?
Yes. All the evidence, the medical examiner, I think both eyewitnesses, these were close range. And there was evidence that blood spatters. I mean, what I said is what the evidence was, is uncontested, that they were close-range firings. That's why the prosecutor said Oh, that's why she said, he was wearing these sneakers as he stood over the prone body of Frank Ciuccolo, the prone and bleeding body of Frank Ciuccolo, and blasted into his body. That's when we know he was in the presence of blood. And she connected that to the test that she called an objective test for the presence of blood.
Then explained all the rest of it by washing. I mean, in other words, that there was just this.
Ruled
this
it out,
whole
we ruled
thing
this
on
out,
the soul.
everything else was ruled out.
But
So,
there was no question that she was asking the jury to infer that even if the blood tests only identified it as somebody's or some kind of blood, she essentially eliminated all other possible, by argument, but all other possible sources of blood other than Ciuccolo.
yes, that's what she said. This was Frank Ciuccolo's blood.
Ms. Ibbotson, refresh my recollection. The testimony was that it did test for blood, or that it test consistently. Could it have been plant food?
They call it a test for presumptive blood.
But not necessarily.
Human blood, animal blood, or other some plant matters,
or plant
peroxidases.
matters, not blood at all.
It could not. We argued. We agreed with Justice
That was
Wilkins.
the testimony. The testimony was
Yes.
it could be any of these things.
Correct.
But it was
And she argued we ruled those other things out.
I don't
So
know
it
how you
starts
do it.
presumptively blood, but if the presumption is met, it could be plant material.
Yes, that's correct. But it's I just to focus on Justice Gant's question. Yes, of course, this court must look at it the way a reasonable juror would have looked at it, not a learned jurist. That's what the issue is all about, and the test is whether it would have been a real factor in the jury's deliberations. And I'd like to turn my attention a little bit to the purported strength of the Commonwealth's case between these two eyewitnesses. Repeatedly, reference is made to the fact that these were independent identifications. Well, I'd like to actually question that. What happened here is that Storella, who everybody admits was a criminal and a perjurer, identified Frank DiBenedetto. And then Frank DiBenedetto was arrested, and then he was arraigned, and Globe photographer took his picture at arraignment, and that photograph, page A94 of the appendix, was printed right next to an article that Joseph Schindler, who had up until now told the police he couldn't identify anybody, didn't think he could, and he gave a very bad description. He read the article. 3 days later, he went to a lineup and picked Frank DiBenedetto out of a lineup. Now,
Wait a minute. Does he admit reading the article?
yes, he does. And he said,
Did he
but
admit seeing the picture too?
No, he said, this is what the evidence was, and I'd really like to be able to wrap this up. He says, I told my secretary, my law partner, to scissor out any photos about this article. And those two people testified, and they would not corroborate. And the secretary said, I don't remember it. And the law partner said, it never happened. Now, if he wasn't lying, why would those people come in and
But what never happened?
the instruction to scissor.
But were they saying they never gave him the article?
No, he says he read the article.
He said he gave.
He said he read the article.
They say about the article.
He said.
No. What did?
Excuse me, they said, the secretary said, I don't remember him ever telling me to scissor out the photo. And the law partner said, he never told me to scissor out the photo.
Did they ever say they gave him the article?
No. He said he read it.
He said he read it, but he didn't see the photograph
Because
he had told the secretary and his law partner not to give him
to scissor it out.
Not to show him photographs, to sizzle it out. And
Yes.
both of them
said that never happened. Now, the jury heard all this, but the one thing the jury didn't hear is evidence that would have cast real doubt on what he had to say. So I just want to make it clear, these were not independent identifications. This photograph is based on Storella's identification, and the jury could have believed, if they didn't have exculpatory evidence before them, that Schindler said it was my ID at the lineup was based on my independent recollection. And I want to close with something a little bit different, if I may. It will just take a moment. A little bit new, and I did tell my sister I was going to bring this up. There was one other person in that photo, Paul Tanzo. I'd like this court to take judicial notice of the fact that the records of Paul Tanzo's retrial show that the Commonwealth did not use the sneaker evidence at his retrial. And what was the result? Not guilty. Now, without the presumptive blood evidence or without exculpatory evidence showing no blood on those sneakers, What would have happened at Frank DiBenedetto's trial? Can this court be certain in justice that justice was done in this case? I don't mean to suggest that the Tanzo result is the be-all and end-all, but I offer it as, in the Commonwealth's words, a small piece of corroborative evidence that justice was not done in this case.
But what did Schindler say about Tanzo?
He identified him at the lineup, just like he did.
But wasn't there some evidence that Tanzo wasn't there?
Yeah, that was one of the versions of Storella's story. Storella gave
But
a...
that's what I meant. Storello said that Schindler that Tanzo wasn't there.
Yes. At one point he put himself... But still, Schindler's identification, everybody says Schindler's the crux of this story, not Storella. Everybody knows he's a liar. But the jury, Tanzo's jury didn't believe Schindler either. And he identified Paul Tanzo after he read the Globe article.
Thank you.
Thank you so much.
Ms. Sivison. Ms. Newsom?
Good morning. I'm Eliana Newsom with David Apfel. I represent appellant Luis Costa. The newly discovered evidence obviously applies more directly to DiBenedetto, but it also would have been a real factor in the jury's deliberations as to Costa, and therefore requires a new trial for Costa as well.
Was there I know I should know this, but there was joint venture instructions?
There was a joint venture instruction.
Was there anything separating out, the verdict slip, separating out joint venture versus individual life?
I don't believe there was, but I'm not certain about that. First, the newly discovered evidence calls into question the credibility of Storella and Schindler, the only two witnesses against Costa. Justice Gantz was right when granting Costa's leave to appeal. He said the significance of the newly discovered evidence is the same for both DiBenedetto and Costa. This court acknowledged in 1998 that both DiBenedetto and Costa's convictions depended on the credibility of Storella and the reliability of Schindler's identifications. The trial court in 1994 admitted the 1994 sneaker evidence against both Costa and DiBenedetto, denying Costa's request for a limiting instruction and saying that the evidence corroborated the witness's testimony and there would be no limitation. The newly discovered evidence not only eliminates that 1994 corroboration, but it also discredits the testimony of Schindler and Storella.
Now, speaking of Storella, I gather, was a friend of DiBenedetto.
Correct.
Was he also a friend of your client?
I believe, yes. He said that he had known him for a long time.
Right,
he also was supposedly a friend of the victims. He was a friend of
I gather, didn't the fiancé of one of the victims put him in her home with the victims, or put him near the home with the victims just
No,
before?
Diana Curtin had testified about Ciucciolo and Storella being together before the crime.
Right, just before. So he was with one victim just before the crime.
Storella was.
Right, Storella was.
Correct.
So certainly he would have had knowledge, and I gather the evidence was pretty clear that it was Storella who set them up.
That was Storella's testimony.
They were certainly lying in wait for them at the park.
That was Storella's testimony.
And is there any reason why Storella, at trial, was there any particular reason developed as to why Storella would testify against his friends DiBenedetto and your client?
No, there was no credible evidence as to why he was telling any of the many versions that he was telling. As Ms. Sibison said, everybody has agreed that Storella was a liar and that his story changed multiple times. But this newly discovered evidence shows that none of the victims' blood was on DiBenedetto's sneakers, and therefore Storella and Schindler could not have seen what they claimed to have seen, which was DiBenedetto standing in a pool of blood around all of this blood, and evidence suggesting that Storella and Schindler were wrong as to DiBenedetto being there would have been a significant factor in the jury's deliberations about whether Costa was there as well. I see my time is up. If I could just have a few more seconds.
With regret, you have to be a far more experienced advocate like Ms. Sibison, who keeps talking and who doesn't ask. So next time, thank you, Ms. Newsom.
Thank you.
Ms. Foster, good morning.
Good morning, Your Honors. May it please the Court, Chris Foster for the Commonwealth. I just want to jump to the point that there was overwhelming evidence here, and I think Judge Mulligan has found that, and as both the trial judge and the motion judge,
we understand the standard of review.
Correct.
I have to say, and I thank you for doing it, that in your brief you're very clear about what the prosecutor said, but it is a pretty strong argument about the sneakers, and of course I haven't looked at the entire closing argument, but it continues longer than what Ms. Sibison was reciting to the court.
It does, but I think the important part is that the jury did obviously hear all the evidence that was introduced. The Commonwealth's witnesses could never even testify that this was indeed human blood. They testified that it had presumptively tested positive for blood, but that they couldn't
No,
go
I
any
understand that,
further.
and the prosecutor, I take it, drawing the inferences that, was it a he or she? She could reasonably do, goes on to say, that's when we know, that's not speculation, that is independently corroborated. I mean, she's really hammering it home, perfectly permissibly.
I think the difference is she's not hammering home that because there's blood on these sneakers, we know he was there. It's because he was wearing these sneakers. Joseph Schindler testified that he identified the tallest of the three assailants, who he later identified as DiBenedetto, wearing white Nike sneakers they used to be white, but they are now soiled with a red swoosh. And DiBenedetto was actually arrested wearing these sneakers.
But how much credibility should we give to somebody looking out of a window or a balcony at what sneakers somebody is wearing when they're Nike swoosh sneakers? It's not exactly a rare brand.
I agree, but I think it just goes to part of his description, and I think the fact he could identify DiBenedetto and Costa in court and in lineups, I think that also goes to it. He didn't only identify DiBenedetto based on these sneakers. I think that's just one small bit of corroboration, which, as the prosecutor said, was one small bit. He testified that he had an opportunity to see DiBenedetto's face. When DiBenedetto was leaving the park, it was very icy, so Schindler testified he had to walk very slow, almost hunched over to get out without falling. And at that point,
Can you begin to formulate the defense counsel's closing argument?
the defense counsel's closing argument.
No. Assuming that we were to agree with Ms. Sivison and Ms. Newsom, which I'm not saying we are, but I can begin to formulate a closing argument. You attack something along the lines of Justice Gant, window, night, ordinary sneakers. Now he says absolutely the sneakers, and that's what puts him there. Then all the blood, no blood linking him. I mean, you really have a different case, don't you?
I disagree. I think the defendants are making short shrift of the fact there were two eyewitnesses here. Schindler and Storella were two complete strangers to each other. They had no interest or stake in each other's testimony, yet they testified to almost exactly the same story of what happened that evening. I think that, corroborated by the medical examiners and the ballistician's testimony, all goes to make this a very overwhelming case.
Well, no, I don't think there's any question as to how these men died, right?
Correct, but those two individuals didn't testify just to how they died. Storella testified that DiBenedetto had a .38 with silver color hollow point bullets in it. The medical examiner testified that each body the medical examiner had recovered from each body silver colored hollow point bullets. I think right there that's some corroboration. And the fact that Schindler testified that when he was looking out the window, as DiBenedetto was firing shots, Cucciolo was starting to run. Storella testified that as soon as DiBenedetto started to shoot, Cucciolo ran. And then also the fact that DiBenedetto, as the three shooters were leaving, DiBenedetto stopped, turned around, and went back and stood over the bodies of each of them and fired several shots into them. Schindler testified that he observed that, and Storella testified to that too. I would suggest that there's no way either of them, or especially Storella, if he was lying, he wouldn't be able to testify to that.
Did they both testify before the grand jury? That is, Storella and Schindler?
Yes. So I think...
Did they both testify at Mr. Tanzo's trial as well?
I'm not sure. I haven't looked too
At the
much...
retrial?
No, at Mr. Tanzo's trial, the individual who was found not guilty.
Yeah, that's the retrial. Yeah.
Was a retrial him as well?
It was a retrial. I'm assuming he did. I actually haven't spent too much time looking at Mr. Tanzo's case. I only found out this morning that the defendants would be discussing it.
What do we do with the fact that the ADA here spent at least maybe 2.5 pages of her closing discussing this evidence, which you say is of no particular consequence?
She spent roughly 2.5 pages out of a 39-page closing, where the structure of her closing was, here's the important, she went through each important piece of testimony that Schindler and Strella had, and then went to the medical examiners or ballisticians or physical evidence to show the corroboration. And here it was that Strella and Schindler each testified that DiBenedetto stood over one of the victims firing several shots. And then he said, and we know it's DiBenedetto because he's wearing, one of the things is he's wearing these dirty white Nikes with a red swoosh. Additionally, we also have this, what presumptively was tested for blood. So I would offer that the blood part was just one of two pieces of corroboration for Schindler's and Strella's testimony. So there are really four pieces of evidence that go to show that it was DiBenedetto standing over and firing several shots into this victim's body.
I'm sorry. We've got Strella, we've got Schindler, we've got supposedly the blood. What's the fourth?
The shoes themselves. Schindler's testimony
that those
the
were
one,
the shoes I saw from the balcony. I know those shoes anywhere.
Yes, and he identified those shoes at trial. So I think that that's not the only piece of corroboration, that it was DiBenedetto standing over.
The position that we are in, though, is not to look at whether or not the Commonwealth, absent this evidence, the Commonwealth can prove its case, could prove its case. That's not the test. It's a much more difficult test for us, in a way, which is to look at the entire proceedings. And often, in the cases where we look at this, we look at the closing arguments of both sides.
Correct.
Of both sides. What did the defense counsel, what did DiBenedetto's defense counsel, what did his counsel say about this evidence?
In closing, they said that they had their expert testify that it was probably plant peroxidase.
So he didn't ignore it.
No.
That's not unimportant. Of course, if it had been not important and you really don't have a lot going for you, you may just let it go.
I think that's ignoring the fact that the jury heard all of the testimony that this isn't even human blood necessarily. All we know is it could be some type of animal blood, but it also could be plant peroxidase. It also could be something he stepped in if there was a trace amount of blood. The jury heard all of this.
But you say that, but then the ADA is saying plant peroxidase, eliminated. And you heard how that's eliminated. I mean, she's going through each of the alternatives, eliminated. So there was evidence, but the ADA is saying these have been eliminated at trial.
Correct, and I think that it was a reasonable inference to make, albeit a very, very weak inference for her to make, and I would...
Don't undercut your prosecutor at this point, right?
Excuse me?
I wouldn't undercut the prosecutor. She can argue that.
Exactly, but
and juries argue that. We all wait for the LA law closing argument. I mean, I'm not being flippant about this, but what prosecutors and defense counsel do is to marshal the evidence, make it a coherent story for the jury to understand. How many days was this trial?
The evidence was 12 days.
That's a long time.
Correct.
It's a long time. And so what they do is pull it all together in a coherent, we hope, fashion for the jury to understand.
Correct, but as the jury was instructed and as the court knows, closing arguments are evidence, and they're allowed to be enthusiastic and assert their argument.
Nobody's saying it was an improper argument. The point is just that it's hard to discount it because she actually, that is Ms. Broker, actually used it very effectively. That's Ms. Siveson's point. She used it very effectively in her argument, perfectly fairly, but it, but now when we look at it, can we say, well, yeah, but she didn't do a very good job? I mean, that's sort of where you'd have to come out, isn't it?
I disagree, and I would also direct this court to its own decision in the defendant's direct appeal. There, this court said this is a case of overwhelming evidence. This blood evidence was marginally instructive at best. This court said that in the defendant's direct appeal. And I would also point the court to the First Circuit. In DiBenedetto's habeas appeal, the First Circuit also said that this is overwhelming evidence, and that this blood evidence is marginally instructive.
That's when the evidence is in.
Excuse me?
That's when the evidence is in one form. Now the evidence, presumably in a new trial, would come in in a different form.
That's getting to another point I wanted to bring up. This evidence wouldn't be admissible at trial. It's one of the things that the defendants have failed to prove, which is one of the reasons I think this motion for new trial was denied. The defendants would have to establish that this DNA was on the sneakers at the time of the murders.
But they don't care. They may be content without the blood evidence, without the blood tests on the sneakers. That's out.
Certainly, the Commonwealth couldn't. There couldn't be a claim that this was somehow blood from the body.
In a new trial, I would say that would be a much weaker inference.
You couldn't do
Well,
it.
if you make the argument, then the DNA evidence does come in, doesn't it?
Excuse me?
If you try to get in your blood test argument, doesn't the DNA test come in?
In that case, I would think it would, yes.
So either way, it either comes in or doesn't come in which case defense counsel said there's nothing to tie these defendants to the scene at the time.
Correct, but I think we have to back up, and the defendants have the burden of establishing that this is both newly discovered testing methods, that this is admissible evidence, and that it casts real doubt on the justice of their convictions, and the defendants haven't proven any three. They would have to prove that this was admissible, which means they would have to prove
Is there
this.
any question here that this is newly discovered?
The testing methods?
Yeah. I mean, the evidence that we're now talking about, that this is not the defendant's blood.
I think
Not the victim's blood.
I don't think the defendants have sustained their burden in proving that these testing methods weren't available to them at
But
the
you have
time.
the affidavit of Janet Hanneman, for example, which
Correct.
goes right to the point.
She says
My
that testing.
memory is Judge Mulligan did not address
And
that
he didn't
point.
address it. He said, I don't have to get to that because that may require an evidentiary hearing and a lot of expense when I don't
Correct.
need to get there.
Correct.
So that hasn't been fully litigated, but surely there is evidence here.
Which goes to another point that even if this court shouldn't grant a new trial, at the very most it can grant an evidentiary hearing because Judge Mulligan didn't make findings on admissibility or that these were newly discovered testing methods.
Can I just go to the admissibility? It's not clear to me why they have to establish at this point that it would be admissible. All they have to establish, I would think, is that the Commonwealth would not be permitted to argue.
I disagree. I think they would have to establish that this is relevant to some extent. I think there is no relevance to this evidence, actually. DiBenedetto was arrested 4 days after the murders, wearing these sneakers. So right there, this DNA could have come from anywhere. We had several people handling these sneakers, 3 people testing them. David Brody, during trial, was handling these sneakers with bare hands.
All of that was true in 1994 when these were tested, 6 years after the fact.
Correct.
People had been handling, but still the Commonwealth got their evidence in.
I mean, it's relevant because even if it doesn't come in, it keeps out the other evidence. I mean, as you just said, if the blood evidence comes in, this comes in, but it may mean that the blood evidence doesn't come in at all. So it's got a bearing on the...
I disagree because although it wasn't brought up in 1994, yes, these sneakers were handled. We don't know how they were handled. And David...
Isn't that true of all, DNA tests that are run 10, 12, 13, 14, 15 years later?
Yes, but I think we do have to establish that these tests are relevant and are at least relevant. And I think here there's no evidence of them being relevant to anything. We have no idea how these sneakers have been handled.
So I'm sorry, it's your view that if at this trial they had that DNA test result, they would not have been allowed to offer it? To rebut the claim with the blood?
I think they would, but I also think with this DNA evidence that the blood test might not be admissible because it would have no probative value.
Well, I think, isn't that the point? I mean, the point is that if this case is retried, you basically go with Schindler and with Starella and without the blood. That would be what you would have to do at a new trial. And the question is whether or not that's a sensible thing to require you to do.
I still think even at a new trial, if this blood evidence wasn't admitted or the DNA evidence wasn't admitted, we still have a case of overwhelming evidence.
That may be, but that's why Ms. Citizen, I assume, asked us to take judicial notice of another defendant where this was not in evidence.
Correct, but as the court knows, that was a separate trial. I can't
No, but we're
I-
talking about a
There
separate
was-
trial.
There was also no evidence, maybe I'm wrong about this, but was there any evidence that Mr. Tanzo actually fired any shots? Or was all the shooting by
There were
DiBenedetto?
three guns were used.
Correct. 3 guns were used, and all three shooters told, Strela testified all 3 of them admitted to shooting each of
Oh,
the,
okay, okay.
and there were three guns were used on each victim.
Oh, okay. I
So
didn't-
I think inferably, but as I could say, I can't reflect on Tanzo's case, and I think it could also be affected by the fact Strela only ever constantly identified DiBenedetto and Costa as the shooters, where he didn't always identify Tanzo. That's just what I can say without looking at the record.
There was some way in which his statements, and I don't know in what form, changed over time.
Yes, but Strela's statements always inculpated DiBenedetto and Costa, but they didn't always inculpate Tanzo.
They did sometimes, but not other times.
Correct.
Okay.
I see my time is up. If there are no further questions, I will rest on my brief.
Thank you, Ms. Foster.
All right.